Senior Lawyer and Ecosystems Program Lead at Environmental Justice Australia. Since 2012, Bruce has worked in a diverse range of practice areas within environmental and natural resource law. Bruce's work has traversed law and policy reform and litigation. Bruce has worked closely with local community organizations and NGOs in order to use the law to protect the environment, as well as seeking to improve environmental laws. Since 2015, Bruce has advised Indigenous peak bodies and traditional owners in relation to water rights, especially in the Murray-Darling Basin. This work includes seeking to progress innovative legal and policy approaches to achieving water justice for Indigenous communities. And without further ado, I'm going to pass the mic to Bruce.
Ashley, thank you very much. So thank you all for the opportunity to present this talk to you today, and I'd like to thank in particular your course organisers for putting the program together. As is customary here now in Australia, I want to start by paying my respects to the Aboriginal people of the land from which I am speaking and to their elders past, present and emerging. On this continent, their sovereignty was never ceded, and the relevance of this protocol and its terms may become clearer over the course of this lecture. Now, I work for a public interest environmental legal practice that's based in Melbourne, Australia, called Environmental Justice Australia, as Ashley's introduced. Public interest environmental law in Australia is a relatively niche and growing area of law and public advocacy. It concerns legal practice focusing on protection and conservation of the environment, usually on behalf of community groups or NGOs. In my view, which is certainly not a disinterested view, it is an exceptionally important area of law. EJA works across many areas of environmental law and policy, ranging from biodiversity law to climate law, pollution, public lands management, water law, forestry, and so on. Now, I've been asked to speak about environmental justice, and specifically, I've been asked to speak to the work that EJA has done in the intersecting space of environmental law and First Nations justice in our country. Much of that work today focuses on water and water law. I want to talk to that, but what I intend to do is relate, what I intend to do is relate specific collaborations that we've been involved in, and I want to set that in terms of a wider scene. The wider canvas relates to structural and foundational injustice in Australian law. It is injustice that in many ways defines how our legal system governs the environment and how this impacts on First Nations in Australia. This wider injustice is built on a fault line and a proposition of law in Australia. The foundational fiction which continues to influence many, if not most, statutory schemes that govern land, natural resources and environment. And that is that the continent was terra nullius, that it was empty or unowned and unoccupied, that it was a juridical void, and absent law and civilization until British acquisition of sovereignty and state power in 1788 and thereafter. As I shall come to, this formal founding myth of Australia as terra nullius, unoccupied and empty, was overthrown at common law in 1992, but in many ways, law and practice in Australia perpetuates the model and the paradigm of an empty continent, just not via the common law. Oh, sorry, having problems with hearing. Is that better? Can you hear me now, okay?
Yes, we can hear you. Thank you.
Thank you. There was just a note in the chat that it was a problem. So, terra nullius was and remains an absurdity constructed to legitimate violence, massacre and clearance of Aboriginal First Nations across the continent. The doctrine was an ex post facto justification of British occupation, dating from later in the 19th century. Aboriginal peoples have exercised sovereign authority and ancestral connection to this continent for at least 65,000 years, and they've exercised resistance for 223 years. They continue to do so. The Australian state remains truculent in coming to terms with its own relationship to the continent. This is evident above all in the great silence of the Australian Constitution on Aboriginal peoples and on political settlement with them. Now, on that note, let me swing back to the first story that I want to tell you. This concerned EJA's, our work with Aboriginal communities and their organisations, which commenced at around 2015. That relationship's focused on water and on rivers and river country. It's been a steep learning curve for us and a rich experience. What I might do is take these headphones. Will you hear me better now? Okay, hopefully that'll work.
Yes, that's better. Thank you so much.
No worries. I think they're just dodgy headphones. So yeah, on that note, this work concerns EJA's work with Aboriginal communities and their organisations, and it commenced around 2015. So the first story that I want to tell you is about EJA's journey, and it begins in the Murray-Darling Basin. And on that note, I would just want to bring up a map for you so you know the geographic area I'm referring to. So this is the Murray-Darling Basin. And you can see the inset in Australia where it is here. This is the geographic areas that I'll kind of be talking about. So the Murray-Darling Basin is the second largest river basin on the Australian continent. It covers more than 1 million square kilometres or 14% of the continent. The majority of the most populous states of Victoria and New South Wales fall within the basin. It's been the site of major conflicts and contests over land and natural resources since the early 19th century. First, the colonial seizure of land, then into jurisdictional disputes over water, and now conflict over water under a desiccating climate regime. Around 40% of agricultural production in Australia comes from the basin, mainly irrigated. 2 million people live there. There are 22 river basins within the whole Murray-Darling Basin. It includes Australia's two longest rivers, the Murray and the Darling, where the names come from. And it's around the size of France and Spain combined. There are 16 Ramsar wetlands in the basin, among nearly 2,500 key environmental assets that are water dependent. Around 4% or 70,000 people are Aboriginal from 40 nation groups that live in the basin. By cultural and ancestral connection, they are river people. The rivers are pivotal to Aboriginal law, obligations, community and culture. Since 2015, EJA has advised and worked with the peak organisation of Aboriginal nations in the Southern Basin, which is called the Murray and Lower Darling Rivers Indigenous Nations, or MILDRIN. Our work with them is focused on the exercise of consultation rights available to Aboriginal nations under our main national laws governing the basin. More recently, we have collaborated with the Taddy Taddy Aboriginal community in Northern Victoria on legal and policy pathways for Aboriginal controlled water rights on the Murray River floodplain. A key focus of this work has been our involvement in Aboriginal advocacy for rights and control over water management. For MILDRIN and Taddy Taddy, as well as other organisations, an important way of framing Aboriginal involvement in water management is in terms of what are called cultural flows. This is still an evolving concept. It essentially concerns Aboriginal legal rights to water holdings operating mainly under state-based water legislation in order to enable Aboriginal aspirations and outcomes, especially in management of their country, delivery of justice and empowerment of communities. The cultural flows agenda concerns redistribution of water rights to Aboriginal people as a device of healing the land and enabling economic empowerment. And this occurs through development of bicultural foundations to water management. Now, this is all occurring in a heavily over-allocated water system, subject to deep problematic political economic forces, because water is a key source of wealth and power, and also in the context of a mounting climate crisis. I just want to take you to the particular areas I'll refer to in a moment. in this map. A recent project we collaborated on with Taddy Taddy was aimed at bringing together that community's plans for cultural flows at an important wetland on the Murray River floodplain, with EJA's input on how we could use or reform state laws to achieve that outcome. This place is called Marguya Lagoon. Now, if I can just take you to this map, you'll see this is the state of Victoria, where I am, where I live. This is in the southern Murray-Darling Basin, and this is actually a blown up image of the river. This is the town of Robinvale near it, and this is the river. And this is actually the specific wetland that we've been working on, called Marguya Lagoon. Now, river regulation has effectively stranded this wetland from the natural flooding regimes, and the Taddy Taddy vision is to restore it under their custodianship, and in so doing revitalise ecological health and Taddy Taddy law and culture. Legal rules and controls over even this small parcel of land are convoluted and a major barrier to Taddy Taddy aspirations. Usefully, our joint approach, I think, is getting some headlines and maybe traction. We see this collaboration with Taddy Taddy as one building block from below in pathways toward justice and models of collaboration using the law between non-Indigenous NGOs like us and Aboriginal leaderships. It's one example among multitudes of practical dialogue, solidarity, and mutual communities of practice. Our vision, I think, is to edge forward beyond what I would call the colonial project of Australian law, which is one that is typically oblivious to the ancient connections to the continent, or what I would term first law. Now, there are a few wider contextual points that I need to introduce to you at this juncture. The first of these is that the evolving cultural flows model or idea of Aboriginal water rights is still a relatively early or nascent one. Setting out a program and a legal basis for cultural flows is a work in progress. Further, it is not exclusive of other ideas, programs and models that Aboriginal people have adopted for control or authority in water systems. The cultural flows concept is a response to both the highly regulated water allocation systems in the basin and the Aboriginal water agenda. Arguably, cultural flows are a device to build effective, pluralistic or hybrid water governance in stressed and over-allocated water systems, river systems. This goes to the heart of questions of justice, as that model of water governance is predicated not only on the recognition of Aboriginal first law and culture in water management, but also forms of parity and equality for Aboriginal voices in the operation of law and practice, such as through principles of free, prior and informed consent. These conditions are effectively absent from law and policy governing water resources now. Now, there's a second point that I need to make, and that is that Aboriginal cultural, spiritual and juridical connection to land and waters, or what I've called the ancient first law of rivers and water. Now, this is a complex space, and I'm non-Indigenous, so it's not my space, but it's fundamental to what I have said and what I'm going to say later. We aim to work as allies with traditional owners, with Aboriginal traditional owners. That means we have to learn and we have to exercise humility. As part of that process, we are learning from key Aboriginal concepts and institutions. These include concepts such as sovereignty and country. Aboriginal law and custom is intrinsically embedded in place and in country. It is not static, and you can imagine how rich it is being the product of 1,000 generations. It has confronted genocide and extensive disruption, and I need to explain some of these terms. First of all, sovereignty. I'm going to stop sharing this screen for a minute. Sovereignty. In 2017, a National Constitutional Convention of First Nations delegates from across Australia met at Uluru in the centre of the continent and endorsed what is known as the Uluru Statement from the Heart. I'm just going to bring up a reference to this page online, and if you have time later, I'm not going to show you it now, but I'd highly recommend going and having a look at the video on this site. This is a defining document, and it stated, our Aboriginal and Torres Strait Islander tribes were the first sovereign nations of the Australian continent and its adjacent islands, and possessed it under our laws and customs. This our ancestors did, according to the reckoning of our culture from the creation, according to the common law from time immemorial, and according to science more than 60,000 years ago. This sovereignty is a spiritual notion. The ancestral tie between the land, or Mother Nature, and Aboriginal and Torres Strait Islander peoples who were born therefrom remain attached thereto and must one day return to be united with our ancestors. This link is the basis of the ownership of the soil, or better, sovereignty. It has never been ceded or extinguished and coexists with the sovereignty of the Crown. Unquote. Now, alongside sovereignty, Aboriginal people will also refer to their connection to country. And country is about land, waters, and place that exist through spirit, culture, meaning, and kinship. It has been said that country is like a person or being, but that's not quite enough. The anthropologist Deborah Bird Rose has written, and I quote, country, to use the philosopher's term, is a nourishing terrain. Country is a place that gives and receives life, not just imagined or represented, it is lived in and lived with. Country in Aboriginal English is not only a common noun, but a proper noun. People talk about country in the same way that they would talk about a person. They speak to country, sing to country, visit country, worry about country, feel sorry for country, and long for country. People say that country knows, hears, smells, takes notice, takes care, is sorry or happy. Country is not a generalised or undifferentiated type of place, such as one might indicate with terms like spending a day in the country or going up the country. Rather, country is a living entity with a yesterday, today, and tomorrow, with a consciousness and a will toward life. Because of this richness, country is home and peace, nourishment for body, mind, and spirit, heart's ease. End of quote. There are rules and laws and obligations in relation to country. Past, present, and future, ancestor and unborn generations all come together in country. What I want to emphasise to you in all of this is that the land and the continent is not and never has been empty or nullius. Quite the opposite. It has always been abundant in meaning. Culture, law, rules, and authority and governance and Aboriginal nations are the bearers of the ancestral connection to the continent. The continent has, of course, been colonised. The law inherited through the colonial project in Australia has held that the continent was empty. As I said, the 1992 decision of Australia's High Court, which is our equivalent of the US Supreme Court, in the Mabo case, overthrew that premise in the common law. As a legal doctrine, terra nullius was abolished, and the court held that the common law recognised Aboriginal and Torres Strait Islander native title in land and waters. Native title is Aboriginal and Torres Strait Islander rights and interests in land or waters operating under traditional laws and customs, and where there is evidence showing those laws and customs derive from pre-colonial societies. The law recognises those Aboriginal rights and interests in terms of the settler framework, that is what we call here a bundle of rights and interests comprising title. Native title does nothing to recognise pre-existing Aboriginal sovereignty, that is political or juridical authority and society over the continent. And there are a vast array of laws governing land and natural resources that prevail over native title. Our statute books abound with laws governing land, water, minerals, flora and fauna, and so on. Virtually none of these recognise or defer to Aboriginal custodianship over the continent or the continent's first laws. In effect, the empty continent has not been overthrown on the statute books in Australia. The statute books are where we find most of our laws. This brings me back to water and rivers. In Australia, including in the Basin, the Murray-Darling Basin, and very specifically at Marguya Lagoon and on the Murray River, the fate of rivers and water is affected by what has been termed in legal commentary as aqua nullius. That is, the fiction embodied in law that Aboriginal people's ancient connections to water An authority to speak for river country never existed. Where and how rivers flow, how they interact with floodplains and country, how they are re-engineered, remain in substance issues in which Aboriginal authority, rights and interests are marginalised and excluded, while degradation of the country goes on around them. Now, as evidence of aquanalius in Australia, in the Murray-Darling Basin, Aboriginal people, river people, control less than 0.2% of all rights to water. They may have native title rights in land, but no control whatsoever over water. Now, this perversity, the perversity of this was manifest graphically on the Barker or the Darling River in outback New South Wales, which is one of the other major rivers in the basin. The Barkindji Aboriginal community obtained native title over the river and even rights to fish in the river, but they had no control over water rights, and consequently very large upstream irrigators effectively hoarded water and stopped the river flowing. Water law under the system inherited from the English, both in Australia and in the US, concerns legal rights to the control, use and diversion of water. That is for profit or public purpose. It has no inherent relationship to life, ecosystem health, country, meaning or spirit, other than where that may intersect with utilitarian purposes. Water law reproduces the myth of the empty continent, because no aspect of the deep, ancient, living first law of the continent is inscribed in it. Our water law does not comprehend country, not yet anyway. Now, I've referred to water law as an example of how our laws governing the environment and natural resources are premised substantially on what the Aboriginal leader Noel Pearson terms the gross fantasy of the empty continent. Law designed in the context of the presumed non-existence and practical exclusion and clearance of Aboriginal people continues. That premise operates across many of our laws regulating the environment, public lands and natural resources. They proceed largely as if country and its people are not and were never there. Aquanalius means Aboriginal communities are in a very weak bargaining position over the fate of water resources on their country. In other jurisdictions, such as yours in the US, in Canada or New Zealand, treaties provide a basis on which First Nations existence and laws are inscribed in natural resources laws. That may not resolve a great many issues of justice, but we do not in Australia even have that. My organisation, EJA, still has a long way to go in contributing to a more just nation. There are obvious tensions and contradictions in working within a key pillar of the settler state, that is the law, while making any claims that this same pillar is integral to injustice and absurdities. The way we do environmental law and policy, including that relating to water, confronts powerful forces of reaction, rent-seeking and the status quo. There is a lot of money to be made in continuing to plunder the empty continent. Navigating pathways to use or reform the law away from that status quo is necessary and, in my view, inevitable. Presently, we do it one step at a time, one collaboration at a time, and one example at a time. Perhaps one powerful point to bear in mind here is that the decline of our founding myth of terra nullius, or the empty continent, at common law did represent a major incursion into our national story of the empty continent. It can't be put back together. The prevailing strategy has been to confine response of this fact to native title as a specialist and very complicated area of law. There are many other redoubts and bastions of laws governing the environment, lands and resources such as water, where the premise and the model of the empty continent persists. From our vantage point at EJA, we're continuing to work on these questions and collaborations, and as far as we are able, push forward an agenda of genuine coexistence between First Nations and Australia's non-Indigenous majorities. Unlike in the US, Aboriginal people do not have the benefit of discrete self-governing territories and polities in Australia. The fate of this continent will be in coexistence and reform to the institutions and laws of the state. The forces of reaction assembled against this, like everywhere, are powerful, but in Australia they do not have the cover of a coherent national story anymore, and there is a genuine moral fatigue in this country among non-Indigenous majorities at failing to come to terms with our own history and our own place in the continent. Thank you. That's my talk. I think, Ash, at this point, my intention was to show everyone a brief video that we've done about Marguya Lagoon with the Tatty Tatty community up there. This goes for about 11 minutes, but it'll give you a sense of the specific place and the specific work that we've been doing up there. So I will, and hopefully this will work in terms of people being able to see and hear it. And please tell me if it doesn't. Come closer to the fire now, to the smoke. This is our medicine, good for us, make us feel good and healthy, clean us, make us well. It's my country, my river, my place, good country. Tatty Tatty, Wadi Wadi. This is Tatty Tatty country here, Marguya Lagoon, near Robinbale on the Murray River. This place is Tol Hill in Wadi Wadi. Tatty Tatty is Tol, meaning the lagoon. And also known as Marguya. Marguya Lagoon, it's an ancestral creation site. It's a being, and it's the ancient Murray River watercourse. This is the original Murray River flowing through here, and that's why you've got the cliffs. So yeah, this is an ancestral creation site. It's a part of Bunyul and Milu, creation of the Murray River by the giant cod. You know, for us, this is a very spiritual place. It's a place of, when we talk about giving us, inspiring us to fight for country, fight for our water, Marguya is it's a place of inspiration for us and our elders and our children. It's a very special place, and when it's full of water, it's just a beautiful place. Murray River people, our river country people, we rely on the water from rivers, and that water from the river that flows out into the creeks and the lakes and the lagoons and the wetlands. So we rely on that water. When there's no water there, that has a damaging effect on us, as a physical, but as a spiritual. It destroys our cultural economy, but it also destroys our country. And when you destroy our country, deprive our country of its water, its natural water, then that has a devastating effect on our culture. Because we are water, we're water people, and our culture is water-based. We've been managed, and it's been diverted, manipulated, restricted, prevented from naturally because of the rock and the regulators. And so it's like the veins in your body, you know, if you go and block, a vein, if you prevent the blood from flowing to a part of your body, you're going to kill that body part. It's the same with country. And that's what they're basically doing, killing off the lungs and the organs from the country by stopping water and holding it in the river for the purpose of the irrigators and the farmers to mass pump billions of litres of water out of the river to water their farms. Now, we do need farming, we do need food.
we need balance too. We need to work in accordance with the natural environment and the availability of water.
The state of the river floodplain that we're standing on now is really a product of historic and contemporary regulation of these waterways, of the Murray-Darling Basin in particular. That regulation and that management of water has been highly problematic for decades. Partly the reason we have a basin plan was in recognition of the over-extraction and the crisis facing these rivers and this floodplain. So unfortunately, while we've made some small steps forward, we've actually also got enormous progress yet to make, and we're really facing a major uphill battle in order to restore health to these floodplains.
Cultural flows, it comes from the Chuka Declaration, but it really comes from the spirit and heart of our nations and our country and our waterways. And for us, cultural flows is water, cultural water, spiritual water. It's water for our people, it's water for our country, but it's also water for water. Because the water needs its cultural flow itself. The water needs to flow across country.
Cultural flows is a concept that traditional owners have been developing for a number of years, especially in the southern Murray-Darling Basin, as essentially a tool to identify means of establishing far greater Aboriginal control and authority over water management, especially along the Murray River floodplain here, such as sites like this at Margelia Lagoon. This particular project we're working on with Taddy Taddy is an endeavour to apply that concept to a particular place, to a particular country that is here at Margelia Lagoon. Out of that, what we're hoping is that we can then take this kind of case study and this kind of example as a model of how to progress the idea of cultural flows in practice elsewhere on other country, and other traditional owners might take up that opportunity too.
So, our culture is dictated and informed by and inspired by our waters. You take that water away, you're taking away our culture, taking away our future, you're taking away our children's abilities and opportunity to learn about themselves and about their culture and about their country. Yeah, my daughter Mel, my oldest daughter, I'm very proud of her. She's very special, very strong, and she already has a strong connection to this place. She's leading the way to get Magoya healthy again and make this wetland and this lagoon well again. And she knows that for our own spirit and our own health and well-being, it's important for her to continue to work and fight to get Magoya recognised and for Taddy Taddy to get recognised.
So Margelia Lagoon here is very representative of the Murray River floodplain more generally. There's wetlands along it, billabongs. This country would, prior to regulation of the river, have flooded annually, or at least biannually. So while at this time of the year, in autumn, it would be relatively dry, it wouldn't look like this. It would be, it would dry out and then it would be flooded and it would become an abundant wetland every year. So if we're going to do cultural flows at a site at Margelia Lagoon, a site like this, really what we need to do is bring water over the floodplain into the lagoon here behind me in a manner that mimics how naturally the floodplain floods.
When the water fills that part of the lagoon up and gets too full and then overflows. And that's where the fish ancestors catch all the fish here. There's cooking ovens in the ground everywhere here. That's what this whole area is. It's a cooking site, camping site. Ancestors. We come here today, we come here and camp here. And when there's water here, we come here and come here and observe. We come here and look at country and learn from country and feel our ancestors' presence here. Now, we've been here for 2,000 generations. We've been here for over 100,000 years since the beginning creation time of this waterway. The foreigners have only been here for maybe 230 years. 230 years cannot erase sovereignty for this country. It's ours, it's our inheritance. It's our belonging. It's what we belong to, and it belongs to us. It's for us to care and maintain, to pass on to our children and our future generations. The government has funded the whole cultural flows research project, which has been a really important investment in ideas and thinking. But ultimately, at the end of the day, we need government to go a step further and to provide the resources and the assistance to actually build cultural flows outcomes here on country. And that means access to water, it means traditional owner access and authority over land and over the landscape. And ultimately, the objective of that entire exercise is to restore the health of country. And that's not only about restoring the health of country, but restoring justice to Aboriginal people too. If we can develop a cultural flows program and model that applies to a site like this, like Margooya Lagoon, then there's an enormous opportunity for governments to step up and achieve real gains for Aboriginal people and their control and authority over water and on country. And one of the major important things of that is to reverse the aquanullius that Aboriginal communities are facing, that is basically being shut out of the control and having any meaningful authority over water management, especially in the Murray-Darling Basin. Water that is our water. It's owned by our people, it's delivered by our people, it's managed. We have to prepare that water, prepare country for water, and we have to prepare water for country so that that water is healthy, it's been purified, has all that it needs in that water to be able to look after country, and then country will respond to that water. They need to recognise and afford proper respect to our people, and they need to relinquish that water back to country, back to us. Let water be on country so everything can be well again. Thank you.
Thank you so much, Bruce, for sharing more about your work and the awesome work that Environmental Justice Australia is doing. We'd love to move into the Q&A section now. So if anybody has any questions, please put them in the chat or raise your hand and we can ask you to unmute and you can ask your question directly.
I had a quick question. And yeah, thank you so much for that. It was really interesting, and I love learning about like some of the terminology that you shared as well. I was just wondering, like, what is the is there like high coverage of this issue, low coverage of this issue in Australia? And I guess what is the general like discourse and like public opinion? Sorry if that's like a very broad question, but
It's a very good question, though. I think at one level, the fate of the Murray-Darling Basin has been very big news here. Like, it's quite a notorious issue in Australia, and it has been for a number of decades. Just to put this in some context, which I didn't get to, in the probably the 1990s and 2000s, there was a real crisis and real drought in the Murray-Darling Basin because of over-extraction, natural variation, and there was a lot of those areas that you saw in that video, which are on a much wider scale, were on the verge of ecological collapse, some of those forests. So while most of our water laws are state-based, the federal government basically stepped in to establish a legal framework for environmental restoration and recovery of the basin in 2007. And they produced a quite detailed developed plan for protection and recovery of the environmental assets of the basin in 2012. That required a whole lot of redistribution of water back to the environment. But it's been spectacularly controversial, and its implementation has been what I would describe as a real train wreck. that continues to be really big news in Australia. It comes and goes, but it's still majorly problematic. In terms of traditional owners' involvement in an exercise and the cultural flows agenda and Aboriginal water rights in that exercise, it's been not quite up the same level of notoriety over that length of time, but I think certainly Aboriginal traditional owners have done a really good job of keeping their interests and their profile quite high in this whole debate. One of the more spectacular circumstances is, which I alluded to, which was on the Darling River a few years ago, where because of irrigation, irrigators, the entire river basically dried up and died. And we're talking about hundreds and hundreds of kilometres of river. And that particular scandal, if I can put it that way, was really brought to attention by the traditional owners, amongst as well as other local non-Indigenous people. So they've done a really powerful, and Indigenous people have had a major and powerful role in advocating for the health of the river, which is not surprising because they've always lived there and they continue to live there, and they're very, closely attached to rivers, obviously, because it's their country. And a lot of the areas that, so Marguya Lagoon, the area that I was showing in that video, and also up the Darling River, the one that dried up, those areas are actually have considerably higher proportion of Aboriginal people than elsewhere in the basin. So there's quite a strong Aboriginal presence in those communities. So that also has been quite important and influential in advocacy as well.
Thank you.
I had a question. Something that I was curious about is when you talked about cultural flows in the video you shared, you talked about how the government really needs to step up to provide better resources. So when you're talking about better resources, is that more from like local government, state government, federal government? Which would be kind of most impactful?
Yeah. So the cultural flows idea, it is a bit complex in itself, but the essence of it is reallocation and redistribution of water rights to Aboriginal people. So the heart of that program or that model is going to be about, in Australia, like a lot of your states in the US, water law is really governed by a kind of primary state authority and control over water. So they have a major role to play in water management and in terms of allocations of water. So that redistribution process really requires governments to have an essential role in that exercise. So in terms of government stepping up, first and foremost, it requires some kind of redistribution or reallocation of water management and water rights to Aboriginal people. There's a number of other things that really need to occur around that because, like the law in the US, as I pointed out, water law is about controlling rights in water. It doesn't necessarily control the entire landscape. So there's a need at places like Marguya and elsewhere along that river to have more redistribution of authority and control over the landscape as well. Not just, water's fundamental, it's like the core, but there's a kind of a wider set of shifts that need to occur around that, which again, a lot of that's public land. So the state governments in particular have a key role around that reallocation of authority and responsibility over those lands as well, not just the water. So they need to step up in that space. One thing I didn't mention, because this is relevant, in the areas, the basin is, in the colonial frontier, was one of the areas of quite rapid and devastating colonisation. And so Aboriginal people's connection to those places from a legal point of view has been highly disrupted. So when I talked about native title, which is kind of the form of Aboriginal legal title that we now have in Australia, there's very little native title actually in the basin because of the extensive disruption of colonisation. So there's a need for, that's partly a need for there's other legal mechanisms and devices really needed aside from native title, to enable great Aboriginal control and authority over those landscapes. Native title is quite a relatively limited device in the basin.
Thank you. Yeah, the next question is from Anna. I'm curious what you see as being the main role of the private sector in working towards a solution to this issue, particularly agriculture producers.
Yeah, it's a really important question as well, because the stresses on the basin are largely as a product of irrigated agriculture. I guess it's a pretty vexed question. Like, on the one hand, there's been enormous controversy over reallocation of water to the environment, and that extends to controversies over reallocation of water rights from agriculture in particular to traditional owners. So there is, on the face of it, immediate tensions between key private sector actors in the basin, especially large-scale corporate irrigators, or any irrigators, and Aboriginal people. But I think it's a bit more nuanced in some circumstances than that too. So there are really interesting projects where farmers and private irrigators are collaborating with Aboriginal people to establish effectively kind of private water holdings and private environmental water holder arrangements that enable reallocation and shift of water back to the environment and back to Aboriginal people to use for the benefit of their country. So there's a couple of really interesting projects on foot around that. So I think in part, irrigators and the private sector are stepping up in certain circumstances. In other areas, the tensions are far more dramatic and the conflicts are far more stark, and are clearly driven by a desire on the one hand just to drive as much profit out of irrigated agriculture as possible, and to the detriment not only of Aboriginal people's control over those resources, but just over the environment generally. So it's a bit of a mixed picture across the basin. I mean, as Brendan kind of indicated in that video, ultimately what this is about is striking a new balance, a new deal between the way in which the whole basin has been developed as it's analogous to, say, California in the US in terms of the extent of, over allocation of water resources for the purposes of large-scale industrialised agriculture, and shifting that balance back towards Aboriginal people's control and authority over water and to the environment, probably collectively and jointly. No one's saying we're not going to have irrigated agriculture in the basin, but yeah, there's a real need for a shift and a readjustment. The Basin Plan and the Commonwealth Water Act that I referred to before was intended to achieve that outcome, but it's been really vexed and dogged by enormous problems in its implementation.
Thank you for that. Also funny that you brought up California. There's actually a question in the chat about that. But first I'm going to go to a question from Chandler. In your area of research, is there much emphasis on the commons and universal right to land or water over Aboriginal rights? Or how is the idea of shared resources reconciled with the injustices experienced by the local tribes?
Yeah, we don't quite have the same doctrine or notions around commons in Australia, I think, as you do in the US. We don't, for instance, we don't have the operation in any really substantial scale of the public trust doctrine in relation to natural resources. Here, we would probably frame the notion of the commons more around the idea of public as distinct from private interest, and less around that kind of legal or jurisprudential notion of the commons, and more around ideas of public interest and public good. And water resources obviously are clearly as in terms of their primary governance, are in that category or framework as being a public good. Hence, in Australia, as in many US states, water is, as a matter of law, under the primary supervision and right of the state, or as we would say, of the Crown. The Crown being the state executive power in Australia, and governed under legislation, under Acts of Parliament. That is how, in principle at least, through the state's management of water resources through those primary rights or primary supervision, is that's how, in principle, the notion of water as a public good and managed for the common good is intended to be affected. Now, of course, you get a situation where the state or the Crown has that primary responsibility to govern water in the public interest, and then, of course, divvies it up and licenses it and gives away entitlements to all sorts of actors in the private interest. And, of course, that's how water law has worked in the US as well as in Australia. The idea of, I think the second question there is a really interesting and powerful one, because it goes to the issue of the overlap or the intersection between how environmental law, non-Indigenous environmental law and natural resources law sees water and how traditional owners see water, and where the overlaps and intersections are. So on the one hand, as a matter of law here, we have that notion that that water is a public good to be managed in the public interest. And on the other hand, Aboriginal people see water as integral to their own rights and interests, to the health of country and to the health of their connections to country. What I think with the space we're trying to work in, I think, is the intersection between those two things, where water, the management of water in the public interest as a common good, is also at the same time the management of water for the health of country and for the health of communities. It's not straightforward, because what you're trying to do and what the cultural flows work is trying to do is, as I said, build a kind of hybrid agenda or a hybrid or pluralistic legal framework that recognises at the same time the water law frameworks that we have, which are about that kind of public interest and public good, and Aboriginal law and rights and interest in water, which really comes out of the land and out of the country. So, yeah, there's how we've tried to set it up in the Marguya Lagoon example is Tati have basically set out their agenda and what they want to see on that country in terms of the outcomes in water and land management and so forth. And then we've said, from a legal perspective, there's a whole lot of ways that we can achieve this or chart this through using different legal mechanisms, the water law framework, the public land management framework, environmental laws, biodiversity laws. And we need to redesign and craft those laws to enable joint outcomes or hybrid outcomes that is about health of country and kind of the health of the commons, if you want to put it in that way. I hope that makes sense.
That was great. Thank you, Bruce. Next question here is relating to California. This is from Karsten. I'm from California, and from what I understand, when water allocation policies were drafted decades ago, the state's booming economy managed to coax a lot of water from other states and Indigenous people in the West. Have historical water policies been shaped by regional economies? If so, does that make it harder to execute reallocation you're referring to?
Yeah, pretty much the same situation, except of course, the legal and constitutional relationships here are quite different to the US. So when you talk about coaxing water from Indigenous, from First Nations in the West, I suspect a lot of that was just taking it. I don't know how much it was just coaxing rather than just theft. But leaving that aside, I guess the whole notion here there's no treaty frameworks. There was no, when the water regulatory system was set up in this then colony of Victoria in the late 19th century, and all the states in Victoria operated in the same way. It was done with absolutely no regard to Indigenous people whatsoever. And that's the fundamental, that's the way in which the Terra Nullius doctrine operated, and continues in a statutory form to kind of have effect, is that the myth or the lie is that the continent was empty. So, you know, the politicians and the lawyers and the farmers and the developers who went in to, you know, build dams and weirs and drainage channels and all that kind of stuff all over the Murray-Darling Basin, they just said, no, we don't give a shit about Aboriginal people. Like, we don't have to worry about them. As a matter of law, they didn't have to worry about them because, you know, the inherited law had no regard to them whatsoever. That's the nullius doctrine was that the continent was empty. We can do with it whatever we want. So obviously, that's the original context. What was driven as a result of that in the basin is basically been a century of industrialisation, especially agricultural industrialisation of the basin that's been built around the regulation of rivers. And the regulation of our rivers is like the regulation of rivers in California. It is got to the point where rivers stop flowing, ecosystems collapse. The dynamic, there's a lot of interesting parallels. It might not be quite as extreme. Well, in the basin, it probably is just as extreme as California, to be perfectly honest. And there's a lot of analogies. A colleague of mine actually did her PhD on the comparisons between the water regime in the Southwest in California and Australia, because there's so many similarities. What happened, of course, through especially the second half of the 20th century in the Murray-Darling Basin, especially in the states of New South Wales and Victoria, is they just handed out water licenses like confetti. So it had very little regard to what water was actually there. It basically assumed that you can take every drop, and if anything goes into the ocean, that's a waste of water. That is precisely, that occurred, of course, in a relatively wet climatic condition in the second half of the 20th century. Those conditions have collapsed since the 80s and 90s here. But like California, the climatic conditions are very similar here, insofar as there's a precipitous fall off in rainfall and water flows and things like that. So the regulatory regime we've put in the basin since the 2000s and 2010s has attempted to do a substantial resolve a really excessive over allocation of water resources to industrial agriculture in particular. But it's just hit major hurdles because there's so many powerful invested interests, presumably like in California, I'd imagine. Though I think in some respects you've probably done it a bit better because you've got other kind of more fundamental doctrines that help, like the public trust doctrine. But there's a lot of parallels, I think.
All right, I'm not seeing other questions in the chat. If you have them, put them in, but if not, we can wrap up. Thank you so much for your time, Dr. Lindsay. It was awesome to hear about the work that you've been doing, that Environmental Justice Australia has been doing. Also very surprising to me that there are a lot of parallels between like work that you've been doing and also other situations happening within the US, especially the similarities to California.
Absolutely. Thank you so much too, Ashley, for organising it, and thanks everyone for their participation.
Yeah, I'm just seeing a lot of thank yous in the chat. Thank you again, Dr. Lindsay, for your time, and thank you everyone for taking the time to come to this webinar, and hopefully we will see you at the next one.